This is Stephen Leskin. I am an attorney in Portland, Oregon. I host these webinars every other week or so on topics related to divorce and family law. Tonight's topic is the scintillating topic of discovery and evidence. As I was putting this together, I realized that I could do a whole hour on discovery and many hours on what evidence is. But tonight's kind of is an overview, and I will do a specific webinar on discovery in family law. But tonight is just an overview. As always, if you have questions, you can give me a call. I don't take questions during the webinar, but my contact information will be available during the webinar and on a slide at the end. So if you have questions, you please feel free to email me or call me, and I'll be happy to engage with you. Um, these are intended not as as an infomercial for me. I focus strictly on topics that are important to people going through divorce. And my belief is that the more information people have, the better their decision will be making will be, the less stress they'll have, the more able they'll be able to work with their spouse to resolve things. Um, so with that, let's just get into it. All right, so here's the agenda for tonight. We have the meet Stephen Leskin, me. What is discovery? What is evidence? What is the connection between discovery and evidence? And then finally, how is evidence used in trial? So that should take us for about an hour. A little about me. I've been practicing law in Oregon since 1992. I've been doing family law since about 2001, 2001. I in downtown Portland, just outside of downtown Portland. You're welcome to contact me. Here's my contact information. The last couple of years, the focus of my practice has been largely divorce mediation. You can find my website at One Day Divorce Mediation or leskinlaw.com. Both will take you to the same website. My divorce practice um, is unique in Portland. I do something called a hybrid uh, mediation binding arbitration, and you're welcome to check that out. Let me advance the slide. Okay, so let's get into it. What is discovery? And you'll hear that term a lot, and in litigation, you'll hear that term a lot because it's crucially important. It's what attorneys spend a lot of time on. It's where people run up significant legal bills for the attorneys to do discovery, but it's crucial for getting a good outcome in your case. So discovery is information which helps to prove or disprove any element of a lawsuit. So whether it's a criminal case or a car accident case or an employment case, there's going to be an exchange of discovery. So let me take this out of the divorce context for just a moment. In a car accident case, the injured party may be required to produce medical evidence of their injury, right? Or they may be the person who caused the accident may be required to cough up their insurance policy so that you know that there's insurance or what the limits are. In a criminal case, the defendant has the right to see the police report and all the work that was generated by the police, including surveillance or undercover things. So there's always going to be an exchange of discovery. In family law, in a divorce, I like to think of it not as discovery, but as an inventory. And you are creating an inventory of everything in the case. For example, you're creating an inventory of all of the assets. You're creating an inventory of all the bank accounts. You're creating an inventory of all the real estate, of all of the liabilities. Uh, if it's a custody case or there's a custody case within the divorce, you're gathering information. It's not really an inventory, but you're gathering information about um, the parents and what they how they parent, and ultimately you're helping the court decide uh, what's in the best interest of the child, and you gather that through the process of discovery. Discovery can be found in one of two places. Kind of obviously, one would be in the care and control of care, custody, and control of one party or a third party. So, for example, if you are going through divorce and your spouse has the tax returns, you can ask them for those tax returns or their bank account records or their credit card statements or their stock portfolio. Those are all things that are discoverable directly from the other party. If you want it, if the other party refuses to provide that information, you have the right through an attorney to issue a subpoena to a bank, for example, or to a brokerage house, or to any third party that might have um, the information that you need to build that inventory in the divorce. And the reason it's important is that you want to know everybody wants to be on the same page. You all have the right to be on the same page in terms of what the assets are, what the worth of the bank accounts are, how much money is available, how much debt there is, and things like that. And so discovery is the process of, in a family law case, discovery is the process of building that inventory. And like I said, it can be in one of two places. It can be obviously with the other person, or it can be accessible through a subpoena uh, when it's held by a third party. Discovery is any factual information that is relevant to prove or disprove any claim in a lawsuit. So there's got to be some evidence of relevancy, and relevancy is defined as more likely than not to prove an element of the case, right? So relevancy is that this is more likely than not to prove the point that it's being to prove the point that's being asserted. Um, in Uh, the only area that I can think of law that has mandatory discovery is in family law. In family law, the parties are required to produce like tax returns and bank records and real estate records by law, right? Uh, and it's mandatory. If you ask for it, you are required to produce it. Uh, Discovery is not optional. The way I said that might sound like it's optional. It's not. If it's a car accident case and you submit it the other side and you say, I want the medical records of the person who was injured, they're obligated to provide that also. But only in a family law case where there's let me be more specific. Only in a divorce, it's the only area of law I can think of where what is required to be produced is laid out in statute. Also, there is no objection to demanding that the other side produce their tax returns for the past, I think it's 2 or 3 years. I can't remember if it's 2 or 3 years, but in any event, so if this other side doesn't produce it, you can go to court and ask for an order to enforce discovery, and the court is bound, mandated to order the production of that. Uh, the other side can say, I don't have it. But if it's in the care and control of their accountant, then that's considered, if it's in the possession of their accountant, that's still considered care and control of the party because they can direct the accountant to produce those records. The scope of discovery is defined by what the issues are in in a lawsuit. So, for example, in a divorce, you could not ask for um, think of something crazy, the other side to produce elementary school records, from somebody who went to school 60 years ago. There would be no reason for that. You couldn't produce medical records. Uh, uh, well, so let me give an example. Like maybe in a divorce, medical records would be important if there's an issue of spousal support. So one spouse claims that they can't work because they want spousal support because they can't work because they're injured. The party who's going to be the payer would have the right to see the medical records to verify the claim that they can't work, right? But if there was no spousal support claim, the medical records would not be relevant. So um, what is discoverable is governed by what's in the petition for dissolution of marriage and the response. And if the response contains counterclaims, um, then those counterclaims will also define what uh, what the scope of discovery is. So if somebody asks for something, um, like again, like employment records and there's no spousal support claim, you would be justified in saying uh, that doesn't cover any issue in the divorce, therefore it's outside of the scope of discovery. So it's the uh, uh, pleadings that frame the issues that dictate what's discoverable or not. All right, so how does somebody get discovery? Uh, the Oregon rules provide a couple of different mechanisms, and I'm going to go through each of those with you. Um, the first is something called a request for production, and a request for production is a list of items that you're requesting the other side to provide for you, and generally, as a matter of course, the other side will have 30 days to produce this. This may be tax returns, bank records, credit card statements, evidence of liability, evidence of home ownership, evidence of other property, evidence of gifts, and it goes on. If there's self-employment, all kinds of records would be requested showing what the self-employment is, what the income is of the business, and on and on. So those kinds of things are requested through a request for reduction. It gets served on the other attorney or the other party, and they have 30 days to produce all of those records. And then you can object and say, we don't have them. Like, supposing the question is for brokerage accounts, and you write, the question is produce any all records, brokerage accounts for the last 2 years, and you don't have anything. So the answer is just none, and that ends it. Somebody might say, well, it's not within the care and control of uh, the party who's receiving the request, but that doesn't count. You still have to go out and get it because they're within your care and control. Um, so request for reduction can be very broad, and that's the most common way to get discoveries, particularly in a divorce. There's two types of depositions. A request for reduction calls for documents or digital files. It could be auto recordings or video or photographs. Um, A discovery deposition or a perpetuation deposition is spoken testimony, where the attorney sits down with the other party and takes a deposition, which is a sworn statement under oath. So the attorney will ask a question, and the question will call for a factual response, and the other side will answer under oath um, with a factual answer, or what should be a factual answer. And so a discovery deposition could be very broad. It could cover, where are all of your bank accounts? I want to be on record that you have only one bank account at Wells Fargo and you have no other bank accounts. And so an attorney might use that if they suspect that there's other accounts and they want to get the person on record under oath to state where their accounts are. In the event that it turns out that there's accounts at, I don't know, Chase, and you lied about it, then you would be subject to penalties of perjury. And I have seen cases do that. Rarely, but it does happen. So the discovery um, made deposition may be like, if there's allegations of domestic abuse or violence, you may take a deposition to like firm down what you expect the other party to say. And that's not the best example because the only time that evidence of domestic violence would be relevant would be if there's a claim for custody and both parties are fighting over custody. And abuse in a relationship is one of the determining factors of who will get custody of the child. Abuse in the relationship is one of the factors. So if there's a custody issue, it's relevant. If there's no custody issue, then the other side can object and still go forward with the deposition, but those answers may not come in. That whole entire line of questioning may not come in. And that's because, as we'll come to a little bit, character evidence, like domestic abuse is really like about character evidence. It's like he beat me. It's about the other person's character. Character evidence generally, almost always, almost never, I should say, is admissible. It doesn't prove anything. The courts are interested in conduct, not character, and conduct only when it pertains to generally when there's a custody issue. The courts don't care about what your relationship was prior to coming to court, and the reason you come to court is to divide the assets and liabilities at the time of the divorce, and make provisions for the kids or spouse support. Those are the only issues, not who instigated or who was at fault. Perpetuation deposition is done when a third party witness or maybe even the party won't be available for trial. In the case of a party, it may be somebody sick. In the case of perpetuation deposition, maybe there's somebody who has insight into um, how somebody parented or didn't parent, and you take that, and they won't be available at trial. Maybe they're out of state, or who knows, there's just some reason why they're not available. Um, you can come in and give a perpetuation deposition, and then the rules are a little bit different. Um, uh, but you have that option to preserve somebody's spoken testimony. Another way to get discovery is through something called a request for admission. I recently used a request for admission to pin down what somebody's salary would be for spousal support, right? So I didn't want to hire an expert. Client didn't have the money to hire an expert, so I sent a request for admission, and the request for admission read, uh, admit or deny. Um, my hourly wage for being a carpet layer was $20 an hour. And they admitted that, and then that solidified that their wage for purposes of calculating spousal support was $20 an hour. Other requests for admission might be to verify documents as authentic. The signature on this page is yours, for example, or just like maybe just you want to use it just for basic things like data separation or basic things. So, or it could also be used for deciding ultimate facts. For example, in a personal injury case, varying away a little bit, there may be a request for admission on an issue of ultimate, on the issue of like causation, like the car accident caused the back injury. And so sometimes, or the defendant is liable for the plaintiff's injuries. So a request for admission can be used for that. In family law, it's very infrequently. I tend to use them more because I have a personal injury background as a personal injury attorney for many years where they were more common. So I tend to use them in family law cases where other attorneys don't. But it's a good way of like just getting an admission, and once it's admitted, uh, that it's an admitted fact in a proceeding. Something else that doesn't come up too often in family law cases, but did come up a lot in personal injury cases, was physical and mental examinations. Uh, this rarely comes up in family law cases, but for example, um, like in a car accident case, uh, uh, somebody could request that the injured party go to another doctor outside of the regular scope of doctors um, to examine the patient for injuries. And oftentimes, these are called IMEs. Plaintiffs' attorneys representing injured parties call them insurance medical exams. The defendants call them independent medical exams. And that kind of shows the difference between, the way people look at those particular exams. One, you can expect that if you're going to some of these doctors, they'll say, no, you weren't hurt. Meanwhile, your teeth are falling out of your head. But those kinds of things just don't come up in family law cases too often. Very, very, very. I can't think of a single time actually that I've used it. On the other hand, uh, Oregon family law does provide that um, the court can order a parental evaluation, like they can order a custody exam, and that's actually in Oregon law. That if one party doesn't want to cooperate, you can go to the court and get an order saying so and so will do a custody examination to make a determination on what's in the child's best interest in terms of custody or parenting time. There are limitations on discovery, and here are three. The requested documents or the requested documents or testimony has to be reasonably calculated to lead to admissible evidence. So discovery is not a be all end all to get into somebody's life. For example, if you had you, like if you were divorcing a spouse and you were wanted to go over the top and get into every aspect of their life, you couldn't do that. It would have to be related uh, to um, to the issues in the divorce. I didn't leave it on here, but I didn't write it on here. But there's another limitation on discovery for you can't use discovery to harass or abuse somebody, and that's specifically in the statute too. But it has to be reasonably calculated to lead to admissible evidence. So you could not ask for uh, um, you know items that are intended to embarrass or harass or annoy the other spouse. So you can't use discovery as a cudgel. Um, you cannot discover um, an attorney's work product or trial preparation materials. So, for example, if I'm preparing to go to trial and I hire an investigator, uh, and I hired the investigator specifically for trial, that's attorney work product and trial preparation materials. And by statute, that's not discoverable. Um, so, for example, I could hire two or three different investigators, and somebody finds nothing, and the other finds nothing, and the third one finds something. I could not discover, as the opponent, the investigators who didn't discover anything, right? So, work product and trial preparation materials are excluded from discovery. Privileged communications are also um, excluded. There are lots of privileges, and some of them are more porous than others. So, for example, um, I have the right to tell my doctor medical things in confidence, right? I have that right. That's a privilege. I don't have to disclose that. I have that same right with an attorney, right? I don't have to. What I tell my attorney, unless it's things like I'm going to commit a crime, is considered privileged and confidential. Uh, the reason the doctor is more porous is that there are ways to get that information, particularly if it pertains to an issue in a divorce. Like we were talking about, like um, maybe you've confided to your doctor that you have a problem with alcohol. The other side could subpoena the doctor's records and they would get them. Um, or maybe you have mental illness. Somebody has mental illness. You could subpoena those records if they impact on um, ability to parent in a custody case. So privileged communications are excluded from discovery, but there are some exceptions to those, particularly medical, especially particularly medical limited, particularly medical exceptions. All right, so that's all about discovery. That's about going out and collecting evidence. Evidence is what comes into the record. Evidence is what the court will allow in, what the judge will allow in to the record upon which the judge will make a decision. So evidence is any fact admitted by the judge into the record of the case. And like I just said, the judge can only make the decision on the case based on what's in the record, right? The judge can't say, well, I know the defendant or the wife, and I know that this didn't happen, right? If there's no testimony on that, like the judge can't like refer to his own knowledge or something that I heard on the news or she heard on the news. So, uh, uh, um, so for example, the attorney might say to somebody, the husband on the stand, what is the date of marriage? And the husband says January 1st, 2000. Um, uh, that there's no objection to that. Then that's evidence, and the spouse may disagree and say, well, no, we were married in 1995. There's a factual issue, but both of those are considered evidence. Um, uh, And the judge could say, well, I find that one party is more credible than the other, and therefore I'm going to rule that the date of the wedding was in 1995. Right. So those are facts that are admitted into evidence. They're conflicting facts, and the judge will have to weigh who's got more credibility or what the other factors are in the case to make a determination. But both of those are facts that are admitted into the record. Um, if the judge has an inference for saying, no, I think you guys got married in 2010, he has to have some factual basis to draw that inference, right? Like maybe they were both, um, I don't know. I can't even think of a good example, but the judge would have to have like a factual basis for um, the judge can make a credibility determination between the two who has the better memory. But if he's going to pick like some other date, he's got to have some like factual basis in the record to make that determination. It's the judge in a case that allows, or it's the judge in the case that decides what evidence is allowed into the record. The attorneys proffer it, the other attorney may object. It's up to the judge to act as the gatekeeper or the filter for what actually comes into the record. And there actually is a record, and the record is the transcript of the case. And every case, every time there's a trial or a hearing, there's always, it used to be a court reporter who would be sitting there taking stenography and would produce it into a book. Now it's all digitally recorded and there's no more court reporters. But what's recorded uh, becomes part of the record, and then it goes into a transcript, which is a little booklet, and whatever is in that booklet that's admitted is considered the record. Um, there's two ways, there's two types. This is going to get broken down a little bit further. There's two types of evidence. There's documents, which could include photographs, video, audio. It could include medical records. It could include um, business records. It can include a deathbed confession. Um, the, the, uh, uh, the deathbed confession is not, but the others are all examples of documents that come in as evidence. There's also spoken testimony, like I'm telling my story to the judge about what my assets are, what that value of the house is, or what my personal property is. That's witness testimony. So you have documents and witness testimony. And then within both of those, it's going to break down a little further into facts and opinions. Factual evidence is something that's known through somebody's own experience. The evidence code defines factual evidence as something that you know yourself because of your own experience, or you know it through your own senses. Opinion evidence, let's see. Um, Before I get into that, opinion evidence is if you don't know something through your own experience, then you know it through hearsay. And hearsay is defined in the evidence code as an out of court statement offered to prove the truth therein, right? So that doesn't make sense to anybody except lawyers. So it's an out of court statement made to prove some fact of the case, right? It's being offered for the truth, but it's made um, outside of what's being stated by somebody who knows in court. So um, uh, if somebody starts testifying that, like I heard, somebody told me, the attorney will stand up and say, objection, it's hearsay. And the judge will probably say, yes, that is hearsay. Uh, the other type of evidence is opinion evidence. Only a qualified expert, somebody who's been qualified by their experience or by their education, um, can give opinion evidence. So, um, in a custody case, for example, both parents can come in and say, well, I think it's in the best interest of the child that I have custody. And that's kind of considered factual. It's really an opinion, but nobody's going to object to that. If you wanted a third party to come in, like so supposing uh the wife's sister comes in and says, I think that the best that it's best that mom have custody, um that's going to be an opinion. And unless the sister is qualified as an expert, like in child development or social work or something along those lines, uh, or child psychology, and has been qualified as an expert, she's not going to be allowed to give her opinion. So an expert can give an opinion on an ultimate cause, an ultimate issue in the case, like who is it, which parent is it better for in the child's best interest to have custody, or like in financial matters, like what's going to happen in the future. right? So like the house will be worth, excuse me, the house will be worth this much money 5 years from now, or the stock portfolio will be worth, all things being equal, will be worth this much money in the future, or the retirement account will have an actuarial amount worth of X. So only an expert who's qualified by experience and education uh, can give that kind of opinion testimony. So let's just see if we can summarize this a little bit. Not all evidence is admissible. Hearsay, something said out of court, is also not admissible. Documents in which the authenticity is not proven are not admissible. So, for example, um, if somebody comes in with a signed, this has happened to me in the past, comes in with a signed contract, and the attorney hands it to him and says, "Is this your signature to prove the authenticity?" And the person says no, then it's not admissible because it's not authenticated, right? The person is refusing or objecting to authenticate the document. And so you only can authenticate a document through your own experience. But the authenticity is that it is what it purports. The document is what it purports to be. Uh, Documents such as business records are hearsay, right? Like they are what somebody else is saying outside of court. But there is an exception. So, and there are a lot of hearsay exceptions, but let's just stick with the business records. So, um, if a record is made in the regular course of business and it's offered at trial, uh, the person who's offering that has to have some kind of documentation that it is what it purports to be. Like a person who, like the records custodian, comes into court and say, "Yeah, all of these are produced in the regular course of our business," and then it will come in as a business record. Oftentimes, those kinds of things are worked out in advance by the attorneys. So, you don't have to call somebody into court just to say, yes, these are our business records. The I could spend hours talking about this. The Oregon Evidence Code covers things like privileges and relevancies, things that aren't hearsay, and what we are just talking about, and many other topics. Attorneys spend years internalizing the Oregon Evidence Code. It's the filter to keep documents out or get things into evidence. Like before every trial, I personally always do an analysis of how am I going to get this into evidence. And sometimes there may be like multiple, you can anticipate multiple objections to it, and you have to figure out how am I going to get around these, or do I need to get an agreement from the other side that it's admissible, or am I going to have to do something dastardly and underhanded to get it into evidence? Not that I would ever do that, but you have to think about like you have to know what the foundation is to get your um, evidence into the record, which is the whole point of going to trial. Things which are not evidence. Character traits are not evidence. He's a good guy. That's not evidence. It's an opinion, but it doesn't go to any any element of a case, right? So if somebody's convicted of a crime, oh, he would never do that. He's a good guy. Well, good guys do, criminal things too. He could be a good guy in every other respect, except that he likes to set fire to homes when everybody's asleep. Right? He's a good guy. He's got a character defect. He sets fire to homes. It doesn't matter if somebody's a good guy or a good woman or whatever. It's not character evidence like that is not statements like that are not evidence and generally will meet with an objection that will be sustained. Something else which is not evidence in the family law setting is fault. It does by statute. Why people are getting divorced does not matter. Somebody has an affair, somebody abandons the marriage, somebody forgets to take trash out. All of those things are go to fault, and by statute, by Oregon law, um, they are irrelevant and um, not not admissible. Years ago, I had a divorce case, and I don't think the other attorney was very experienced. My client did have an affair. There was no question that she had an affair. She was unhappily married, and She had an affair. And the other attorney spent an hour or half hour, whatever it was, beating her up for it. And at the end, um, I didn't object to any of it because he was using up his time. And at the end, I said, the Honor, he's not put on any evidence of anything relevant to this case. And the judge looked at me and says, "Why didn't you object?" I'm like, "If he wants to waste his time with you, that's his business. But you can't, as a matter of law, you cannot consider it. Even though it came into evidence, even though it came into evidence, the judge could not consider it by law." Another thing that's not evidence is reputation. So, like, you can't put in reputation that, oh, he has a reputation in the community for being a good father. He's out playing with the kids. He's a coach. He contributes to the PTA, whatever. Um, he goes to church every Sunday. That kind of reputational, um, those kind of reputational opinions are not evidence, but by definition, they're not evidence. Like we were talking about with character, um, it somebody could be, have a reputation for being the best dad in the world, but once he gets home with the kids, he beats them with the belt every night, right? So, reputation is not evidence. In a criminal case, uh, you might think that evidence of criminal conduct in the case is relevant. The only time, so suppose that uh, wife beats husband senselessly, repeatedly, and um, that the judge should know that. In a criminal case, the only time that matters is if there's a custody dispute, right? They're arguing over who should have custody of the kids. And the only reason it matters then is because one of the elements of determining custody is whether or not there's abuse in the relationship between the spouses. And so in that case, that kind of testimony will come in. But testimony to prove that somebody um, is beating on the other doesn't have any bearing on how the how the court is going to divide the assets and liabilities of the marriage. So criminal conduct in that sense is more like a character. It really goes to character. The specific conduct um, only really counts um, if there's a custody issue. A better example might be if somebody has DUIs, driving under the influence. Um, if there's like children and um, the person is the kids are at risk of driving with the parent in the car intoxicated, well, it's certainly obviously the judge needs to know that, and that kind of criminal conduct, then it becomes relevant and something that the court would want to know. All right, so let's tie this together. Uh, we start with asking the other side for discovery or asking third parties for discovery because we're looking for evidence to build our case or disprove the other side's case. In a family law case, uh, for example, a lawyer may issue a subpoena to a spouse's bank to prove that a bank account exists or the value of that account, right? So uh, um, you're going through the process of discovery to prove what the assets or the liabilities are so that the court can have evidence to make its decisions. Uh, Another example in a custody case where a child or children's custody is at issue, a lawyer may subpoena school records to show that a child has poor grades and poor attendance when the child is with the other parent. Uh, in a case involving spouse support, another example uh, would be an attorney may hire an expert and to prove a party's earning capacity. So, wife hasn't worked and needs to show that she's just given her education and experience and out of time in the workforce. She's never going to make any money, right? She's always going to be stuck at minimum wage. So you need an opinion to um, prove that to the court. Uh, the discovery issues with that are that the experts' work product, what they did to develop their opinion, is not discoverable, right? So you couldn't say, give me your expert's work product. Um, that would not have to be produced, or any communications between the attorney and the um, expert would not be produced, or things along those lines. So you're developing evidence that's not discoverable to produce evidence in trial, right? All right. So how does trial? Okay. So now we're kind of right down to the crux of the matter. How is evidence used at trial? Like we talked about, only evidence known through one's own experience is permitted. And so evidence is used to prove the elements of a case, like the right to spousal support, the right to an equitable division of the assets and liabilities, the right to child support, right? And so through soliciting spoken evidence and submitting and proffering uh, documents, you build your case. The other side always has the option to object to evidence being proffered if it doesn't meet one of the um, criteria for admissible evidence, like it's not known directly to the person themselves, or it's a business record that doesn't meet, or there's no evidence that it's a business record made in the regular course of business. So, regardless of the type of evidence that's being offered, a proper foundation must be laid. So, you're telling the court why the evidence is uh, being offered, why it's relevant, and why it is trustworthy or why it is admissible. And so, you develop foundations to tell the court these things. If you don't lay the correct foundation, you can expect an objection, and the court very well may uphold the objection, and the evidence isn't allowed. All right. Um, some conclusions. Discovery forms the basis of what the parties know about their case and the other party's case. So uh, parties there should be singular, not plural. So I hope you don't give me a bad review because of that. I made a mistake there. But discovery is a process of determining what you need to know about your case and what the other side is going to say, and you get that through exchanging documents or taking depositions, so that both parties are on the same page. The point is that there's no surprises, that everybody has everything, and that it's an equal playing field in terms of information. Um, Something that's discovered through the discovery process may or may not make it into evidence. It may not make it into evidence for reasons that we've talked about, but good lawyering, should anticipate that, and a good lawyer will get his evidence into evidence and keep the other side from proffering evidence that's damning to them or does, will help to undermine their own case. Evidence can either be generally factual or opinion, and can be documents or spoken. And finally, cases can be won and lost by what evidence is admitted into the record. You can lose a case by, um, not laying a foundation for your financial information coming into the record. The other side could object, and then you're stuck with no evidence to support your claims. And that happens. Um, and so that's using the evidence code uh, 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 strategically to advance your case and undermine the other side's case. So we started with discovery, which is the process of gathering uh, documents and audio and visual and video and verbal evidence, and then it comes into trial and becomes evidence for the record for the court to make its decision on. So that's the overview. Thank you for watching. If you have questions, please feel free to give me a call or shoot me an email. I love to hear from people that they've sat through and watched the video. I'm always welcome. You're always welcome to connect with me and give me a call. We'll talk about this, or if you want to talk about your case, happy to do that too. So thank you for joining me tonight, and have a good evening.